Hello, I'm Attorney Todd Leneve. Welcome to West Virginia Gun Law. Today I want to take a few minutes and talk with you about the law of self-defense here in West Virginia. Stick around. Under West Virginia's law, and the law of pretty much every state, there is a provision that allows somebody to use force in response to a threat to their safety. Whether that force is non-deadly or deadly is typically dictated by the nature of the threat that's presented to the person. But in the event the person can satisfy the elements of a claim of self-defense or legal justification for their actions, they will be allowed to assert that what they did was legally acceptable. Ultimately, it's up to the judge who presides over a case to make a determination as to whether or not your self-defense claim is going to be valid and going to be allowed in the court proceedings. Now, it's important to understand that when a judge makes a determination that he or she will permit you to argue self-defense, it doesn't mean that he or she is saying that you were justified in fact. Rather, it just means that they're allowing you to make that argument to a jury, which will ultimately decide on the merit of your claims. So when we talk about self-defense, it's important to understand that it is not an automatic right. In other words, you have to prove it, as we just talked about, to a judge, and the judge has to make a determination as to the validity of your claim. So in doing so, there is a set of elements that are present under our law that you've got to be able to present to the court, and the court has to be able to look at and say, okay, I see that there is a sufficient basis here for everything that's being claimed, and I can understand why you as the defendant may believe that in fact you had to act in this manner to protect yourself. And so I'm going to allow that to go in front of the jury. We have a number of cases in our state that have laid out the general concepts of self-defense, the general elements, dating all the way back to the 1800s. And more recently, they've been defined a little more clearly each time the issue gets addressed. And we have a very good breakdown of essentially what amounts to 5 elements for a self-defense claim. So let's take a quick look at each of those. The first one involves innocence. In other words, the person who is claiming self-defense can't have been involved in any sort of wrongdoing. They can't have created the defensive encounter. They can't have initiated it by getting physical with the other person. Essentially, we have the obligation to just go about our day following the rules and living in the way that all of us are supposed to live on a day-to-day basis, when somebody else chose to jump into our lives in a way that we hadn't invited that caused us to feel a need to respond. So you've got to be innocent of any wrongdoing. The second point that we consider is what's called imminence. Imminence relates to the immediacy of a threat. In other words, that threat is active and it is going on in the moment that you find yourself having to take action to defend. A threat of some future harm. Hey, listen, you've been getting on my nerves for a long time. One of these days, buddy, it's coming. You better watch out. Watch your back. That's not an immediate threat. That's a threat of future harm that does not entitle you to act immediately with physical force in response. It's got to be a threat that is happening right now. Someone is attacking you, shooting at you, slashing at you with a knife. Preparing to do so is in the immediate act of carrying out that evil intent against you. Okay, so that's imminence. We then look at reasonableness, and the court has to make a determination about the reasonableness of the overall scenario through 2 separate lenses. First is the subjective lens. That means how you perceived it. Did you actually believe that you were in imminent risk of death or serious bodily injury such that you had to take action in response to that threat? If in your mind you can say, yes, I reasonably believe that, then you've satisfied the subjective evaluation of reasonableness. But then we also have an objective evaluation under our law, which means that a reasonable person placed in your shoes in the same moment that you faced the threat you faced would also have perceived it the same way, would have felt that in fact there was an imminent threat of death or serious bodily harm from which they could only be saved through the use of force on their own behalf. So subjectively and objectively, we've got to be able to prove to the court that it was a reasonable conclusion in the mind of the defender and would have been a reasonable conclusion in the mind of an average person placed in the defender's shoes. The next point we look at is what's called proportionality. Proportionality simply relates to kind of a broad concept here. It relates to the relative position of the aggressor and the defender, as well as the nature of the threat that's presented to the defender and the nature of the response that's carried out by the defender. So that gets a little bit complicated, and so trying to simplify it, we look at things that would amount to an imbalance between the parties. Perhaps the aggressor is young and able-bodied, whereas the defender is an older person who doesn't have the same physical skills that they may have once had or can't match up to the aggressor. Perhaps it's a factor of numbers, multiple attackers versus one defender. Maybe it's a matter of physical skills, a young, fit person versus somebody who has a medical condition that limits their mobility, limits their ability to protect themselves. We're looking at a disparity between the aggressors and the defenders. But then we also look at the nature of the threat that's made. Was this a deadly force threat that would justify a deadly force response? Or was it only a non-deadly force threat, which typically will only justify a non-deadly force response? So we have to evaluate the nature of the relationship between the aggressor and defender, meaning, again, what was the disparity between their relative positions and the nature of the threat itself that was presented to the defender. The final point that we look at is sufficiency of the evidence of all of those other factors. In other words, we have to be able to demonstrate to a court that there's enough evidence for the court to consider this claim of self-defense when evaluating whether or not we're going to be allowed to argue that in front of the jury. So we can't just go in and say, well, Judge, it seems like this should have been a self-defense case. There has to be enough that the individual brings me as counsel that I can sit down and say, okay, we have elements 1, 2, 3, and 4 all present. Here's our description of what happened, why you did the things you did, why you perceived what you perceived, and now we have enough to move forward with when we go in front of the judge to make the argument that you should be allowed to argue self-defense in your case. So this is a fairly complex issue. I'm trying to just boil it down quickly here for you so you understand the elements. We've got innocence, imminence, reasonableness, proportionality, and finally sufficiency of the evidence. So it's a 5-element test the way we look at it here in West Virginia. A final point that I want to share with you is that we do not impose a duty to retreat in this state. Many states do, but we are not one that requires that. So in other words, you have the right to stand your ground and protect yourself. Now, as I tell everybody that I speak with on this issue, even though we don't have the obligation to retreat, a good safety plan ought to always consider retreat as the first option. If you can avoid the fight, avoid the fight. It's the last thing that you want to have to get involved in. But if you don't have any way out of it, understand that the law supports you standing your ground and taking the action that's necessary to ensure that you are protected and safe and have another day to go on in life. Listen, again, I know this is a complex issue, and this is one that we could spend a video on each element very easily. So if you have questions, please feel free to reach out to us. You can get in touch through the website below, and we will be happy to answer those questions. Make sure that you understand what your rights are so that when you go out in the world, you have the ability to know what you can and can't do, what you should and shouldn't do when you find yourself presented with some kind of a threat that you may encounter. Again, please check us out on the website. If you haven't subscribed to the channel, we'd love it if you did so. hit the like button for this video, pass it on, make sure that the people that you know are able to get this information, and let's get the word out there on what it takes to develop a successful claim of self-defense under West Virginia's law. I appreciate you taking a few minutes to spend with me today. I look forward to seeing you in the next video. Take care.